for the stream to fire up all across the fruited plains of the internet, and then we can go ahead and get started. We always need to wait for YouTube to get alive and cracking, and let's make sure that it is. It's coming in hot over here. We're going to make sure that we have a couple of these buttons pressed and that it's working. Let's check over on Rumble. We're alive on Rumble and Facebook and Twitter, which means we can go ahead and get started. So let's get right into it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group in the always beautiful and sunny Scottsdale, Arizona, where my team and I, over the course of many years, have represented thousands of good people facing criminal charges. And throughout our time in practice, we have seen a lot of problems with our justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We have judges not particularly interested in a little thing called justice. And it all starts with the politicians, the people at the top, the ones who write the rules and pass the laws that they expect you and me to follow, but sometimes have a little bit of difficulty doing so themselves. That's why we started this show called Watching the Watchers, so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. And we're grateful that you are here and with us today. We've got a lot to get into. We're going to start off by rewinding the clock back a little bit to January 6th. We've got to take a look at what is going on with this case for Couy Griffin. I'm not sure how you say his first name. We're going to probably butcher that throughout the show. But Mr. Griffin is a January 6th defendant, and the U.S. Attorney's Office, the government, came out and they're asking for yet another continuance in his case. They're saying that we are not ready to go to trial. Your Honor, we need more time to continue to prepare our case. It might sound pretty reasonable if you're somebody who's not really familiar with how this stuff works, but we have what is called the right to a speedy trial in this country. Pretty damn important right. And the U.S. government has been just stepping all over it for the last 8 months or so. And so we're going to go through this U.S. attorney motion that was drafted here by Emily Miller and Janani Iyengar over from the U.S. Attorney's Office, because they're saying that they don't have all of the video evidence that they need, and they're asking the court for more time. It's all hogwash, and we're going to go through that. Then we're going to change gears and talk about the fleeing Texas Democrats, the weapons of mass destruction carrying COVID, parachuting, skyrocketing like a missile right into Capitol Hill. They are suing the governor from Texas, Governor Abbott, saying a bunch of strange things, actually. It's kind of a bizarre lawsuit. They're asking for nominal damages like $5, $10, but basically they're very upset that Governor Abbott is doing what he's doing because of the fact that they got up and left. So they, so they sort of fled the state, and then there are consequences for that, and they're upset about the fact that they left the state voluntarily. So we're going to go through that. They are suing now a lawyer who is representing them, a guy by the name of Craig Anthony Washington, and so we're going to take a look at that lawsuit. And then our last segment of the day, Barack Obama is back in the news. He had a birthday party over the weekend, and a lot of people are giving him a lot of grief for this thing. 300 to 400 people there, kind of flouting the CDC rules and not doing so much of the social distancing. But we're going to go through this in a little bit of a different way. You're going to hear from a lot of the people out there in the media. This was egregious and all of that stuff, which it was, of course. And yes, he is royalty, scolding his nose, looking down his nose at the rest of us peasants down here. But we are going to go through this, and we're going to apply the U.S. criminal code to this party that he had, because quite frankly, folks, there's a lot of evidence in the U.S. code, the federal code here for a criminal code, that Barack Obama was running a criminal enterprise. And so we're going to go through this. Video footage has now been leaked out. There were illegal drugs at this party. And so we're going to apply all the criminal codes to the former president. And it's going to be fun. So if you want to be a part of the show, the place to do that is at watchingthewatchers.locals.com. The other place to do that is now on YouTube. We are taking super chats. Those are functional and they're back in business. But the real place to be is over at watchingthewatchers.locals.com, because there's some good stuff happening. And if you want to ask a question and use the form that we have, where you can ask sort of a longer form question, it looks like this. If you're over there in the live chat right now, I'm going to give some shout outs over to Want to Know is in the house. I'm Not Gas is here. We got D Rodrigue 188 who just signed up and joined in on the community. Three Girlies is in the house, along with Want to Know and many others over at Locals. On YouTube, shout outs over to Pro Player 2000. We've got Playing Hooky in the house. Zulu is in the house, says that Trump is in custody. He's in Gitmo, apparently. We have Meh, we have Luke Warmy, Ashley Truth Hurts, and many others. And so we're excited for you to be a part of the show. There are an opportunity to ask questions at the end of every one of these segments. And so get those keyboards ready if you want to participate in on the fun. All right. So without any further ado, let's jump right into the news of the day. The January 6th defendants, if you've been with this channel for some time, you know I've been sort of stomping my feet about the treatment that many of them are facing. We're now in August. It's been 8 months since the original incident happened, and there are still Capitol Hill defendants who are in custody. Many other people around the country commit very heinous crimes and they're released on bond. They get out free to roam the countryside, but not many of these Capitol Hill defendants. We've screamed about that for a long time. The pertinent defendant that we've talked about most frequently, the symbol of this, was, of course, Jacob Chansley. Now, there's something else, sort of this less volatile, less in-your-face due process violation that is happening with many of the January 6th defendants, and I want to spend some time talking about it, because it is pernicious. This is something that is a huge, huge problem, and not many people are talking about it. So we've got a couple things that we're going to do. We're going to dive into this man's case. This is something that we've been seeing with many other defendants. His name is Couy Griffin. He's from, we're going to dig into it, see where he's from, but that's what he looks like, right? He's a Trump supporter. He is the founder of an organization called Cowboys for Trump, I believe. He had many Trump rallies, rides the horses. He's got a lot of images on online with him with horses and all of that stuff. I don't care about any of that, right? I don't really care about what this man does or what his background is, whether he's an insurrectionist or a Trump supporter or just an everyday citizen. It's not really relevant. What is relevant is what the government is doing to this man, and not just him alone, but him and many other similarly situated Capitol Hill defendants and other defendants in general. But this is something where it has just been absolutely egregious. And so we're going to go through this motion here. It's called the United States motion to continue, right? They're asking for a continuance. What this means in layman's terms is an extension. They're saying, Judge, we need more time. We're out of time. We need more time. Can you grant it to us? But they're also asking to exclude time under the Speedy Trial Act, right? And this is a pretty important concept here that I want to make sure we spend some time deciphering, because this is happening in many, many other cases with the January 6th Capitol Hill defendants. All right, so we're going to do a little bit of background understanding, get into the framework of what we're talking about here. But you may recall from your constitutional class when you were going through social studies or I was going to say civil procedure. I went through that. Hopefully you didn't go through that. But your civics class, learning about the Constitution and all of our brilliant amendments in their glory. You may recall the Sixth Amendment reads something like this. In all criminal prosecutions, which the January 6th defendants are accused of, or they're being prosecuted criminally, the accused shall enjoy the right to a speedy trial, right? It's in the first stinking sentence, right to a speedy and public trial. And what they say is that defendants, criminal defendants, are due this right to a trial without unnecessary delay. And without going into the entire framework of the constitutional underpinnings here, speedy trials are pretty important, because we don't want a situation where the government, a dictatorial government, a tyrannical government like the founders were facing, without any sort of recourse against that government, what they would do is they would charge people with crimes and they would let them just float around in the criminal justice system indefinitely. You ever see the movie Count of Monte Cristo, right? Dantes, right, is thrown into the prison for indefinitely. Well, when am I going to have my right to a trial? Well, when we get around to it, it might be in 35 years, but you can just throw him away and forget about that person, because the justice system grinds slowly. And there are a lot of consequences for that. When somebody is charged with a crime, this gentleman or anybody charged with a crime has those criminal charges hanging over their heads indefinitely. They have the media talking about him in this case. They have job opportunities and all sorts of problems that are going to come out as a result of just being charged with a crime, right? They haven't even been convicted of anything yet. Never had a trial, never agreed, I'm guilty, I will take the penalties, nothing. And so these Capitol Hill defendants all enjoy the right to a trial, the right to a presumption of innocence, the right to know what evidence is being proffered against them now, right now, not 8 months later, which is now. They need to know what it is immediately so that they can begin preparing their defenses. This is fundamental to our system of law. And a government that continues to delay and delay and delay is violating that right to a speedy trial. And so we're going to go through this and we're going to analyze what it has to say and what their excuses are. It's August now. This happened back in January, and they are still twiddling their thumbs, and we're going to dig into it. So what is the Speedy Trial Act? We're going to get some information about this from the motion here from the court, from the prosecutor's office. But just so we have our bearing straight, it says the Speedy Trial Act of 1974 establishes all of this stuff. Time limits for completing various stages of federal criminal prosecution. The information or the indictment must be filed within 30 days from the date of arrest. Okay. And then within 70 days, trial must start. 70 days, trial must start from the date the information or the indictment was filed. Okay. So we're going to see these dates. We're going to see an arrest took place, and we're going to see an information or an indictment being filed. And we're going to see here, according to U.S. Code 3161, that trial must commence within 70 days, right? Now, there are all sorts of exceptions here. And so this comes from 18 U.S. Code 3161, C1. You can go in here, but you're going to see there's, a bunch of different C's and D's and all sorts of different exceptions, which is what the government is going to rely on. They're going to say, yeah, I know you've got a right to a speedy trial, but. All right, so let's get into it. Let me show you how egregious this is and what an embarrassment this is actually for the entire U.S. Attorney's Office. And you can tell them I said that. Here is the introduction from the motion. We can see here the U.S. of America here moves the court for what? A 60-day continuance. This was filed August 9th. And the government needs 60 more days, right? So it's almost like the CDC extension or the student loan extension. The Department of Justice also needs an extension because they also can't get their act together. So 60-day continuance. So that's going to put us, what, August, September, October. All right. So same day as, I guess, the CDC is going to stop their moratorium on eviction. So same type of thing. To further exclude time. Now, what does this mean? All right. So we just went through and we knew what the deadlines are. So let's say we want to take a step back and you've been charged with a crime. Let's say it's a DUI. Let's say it's in the state of Arizona. Our rules here say that we have our own speedy trial rules. And the goal is to have your case concluded and done and closed within 6 months. The Supreme Court has some rules about that. They want to accelerate your cases through the system. They don't want a bunch of endless delays, and they want you oftentimes to close your cases out relatively quickly. So it's one less case on the docket. You, as a defendant, have a right to a speedy trial. And so if you're charged with a DUI, you might come in there and you say, no, I'm innocent. I want my day in court. I want to set my case for a trial. At which point in time, it's the government's duty to produce the evidence against you. If they say you were driving under the influence, well, it's their allegation. They got to prove it. Show me the blood results. Go get those blood results analyzed and get them back onto my desk. Give me the discovery so I can analyze it and prepare my defense. And this is a strategy that defense attorneys use regularly. It's, okay, we're going to go right to trial. You charged me. You've got to prove it. And you've got to prove it right now because there are all these speedy trial rules. So wait until you have the evidence to bring the charges. Or if you bring the charges, you better come at it. Come hot, because it is now our opportunity to demand a right to a speedy trial, to demand that we go in there and have our day in court. And if the government can't produce that evidence against you, guess what happens? That case should be dismissed. It should be thrown away because the government charged you and they couldn't prove it within the time frame. And so the penalty for this, when the government screws something up, is a dismissal. It's a throwing of the case out. It's got to go away because you can't really penalize the government any other way. How are you going to penalize the U.S. attorneys here for delaying and dragging their feet on everything? How do you penalize? Are you going to fine them? No, it's the U.S. government. The fine comes right out of your tax dollars. So money doesn't do anything to them. Are you going to sanction these lawyers or Merrick Garland or any of these people? No, the answer is no. Nobody's going to do that. And they're all going to point their fingers at each other and just say, no, it's bureaucratic incompetence. It's not my personal fault. I didn't screw it up. It's just the fact that our Justice Department is so overburdened or whatever. So there is no accountability for many of these people other than to say, you screwed this up so badly, your case gets dismissed. You don't get to bring the charges against this person and get that conviction that you are so salivating about. It doesn't count because you botched it. But they're not asking for that here. They're asking for more time. We need more time. And so when we talk about excluding time, I know we're going deep on this, and I know this is probably a little bit deeper than many people might want for a sort of a topical show, but we're talking about, if we go back to our 6-month hypothetical in an Arizona DUI case, the question would be, if you need more time as the defendant, you have a right to a speedy trial. You can have your trial right now, immediately. But you can also waive your right to that speedy trial. And so let's say you're charged with a DUI. The government is prosecuting you. They need some time. They need some time. They need some time to investigate you. All of that time counts against the government. There's a 6-month clock that is ticking. Every time, it's like a game of chess. Every time the government asks for a continuance, that counts against their time. They only have 6 months to work in, and so they need another 30 days. Yeah, you can have 30 days, but that goes against your clock. You only have so much time to bring these charges, and you need time. That's fine. We're going to ding you for that. If the defendant here asks for more time, then it's going to come off of the defendant's time. So they have the right to waive that time. And so everybody's sort of keeping tabs on time, and this can be a very, very important part of a defense. So in this case, the government is asking for a continuance. They want 60 days, as you can see, and they're also asking that time is excluded. Okay, so that when the government gets that continuance, it also doesn't count against them. It shouldn't count against us. Why, Judge? Because of all these extenuating circumstances. So let's dig into it. Enough of the background. You're going to see here they're referencing the same U.S. Code 3161 with all these different exceptions, B1, B2, B4, 31, H7A, and we're going to see all of that. Let's get into this actual case. So the gentleman that we're talking about is... Here, he's a defendant county commissioner. He's from New Mexico at Otero County, and he's charged with a couple different crimes: entering and remaining in a restricted building and disorderly and disruptive conduct, okay? Those are the two crimes. Nothing violent, disorderly, disruptive conduct, okay? So that's, you can get that at a bar in Old Town Scottsdale or 6th Street or wherever you go. Entering and remaining in a restricted building, so trespass, right? So criminal trespass are essentially what those are. These happen all the time. Everywhere there's a bar in your town, this is happening. Disorderly conduct and criminal trespass, the two of the most common offenses in the country, happening right here. Okay, it just happened to be the Capitol building, so that changes everything apparently. These charges arise from his conduct on January 6th, got that, climbed the west steps of the Capitol, a restricted area where he remained for 1.5 hours and used a bullhorn to address other rioters, okay, on the west steps of the Capitol, which is a restricted area. Now pay close attention to this because there are two things going on in this motion. One, the government is acknowledging that they need more time in a continuance because they have a whole bunch of discovery that they didn't disclose to the defense. We're talking about discovery here. What is that? It's evidence. It's the evidence that the government has. They need to disclose that to the defense because the government is in possession of that. If the government wants to charge somebody with the DUI, well, they've got the blood, they've got the body cams, they've got the CAD dispatch calls, they've got all of the evidence. And so they've got to provide that to the defense so that the defense can begin preparing for their defense. And in this case, the government has a lot of that. So the question is, what do they need more time for? We're going to get into it. Let's see here. Defendant was arrested on January 19th. Wait, I forgot my second point. The other point of this was discovery, that it's not being disclosed, but also in the discovery, there are questions about whether or not the government is in possession of evidence that shows that the police officers were sort of acquiescing to some of these rioters or protesters coming into the restricted area, which is what flagged my attention here, right? West steps of the Capitol, a restricted area. There's going to be a question about whether the U.S. government has evidence that shows that maybe this portion of this restricted area, people were being welcomed in by these officers. We're going to get there. So he was arrested on January 19, 2021, initially detained. Thankfully, this guy was released on his personal recognizance on February 5th. Okay, so he was in custody for about 3 weeks, and then he got out currently. So you've seen me on here ranting just in a fury about this when they ask for continuances and they don't let somebody out of custody, flagging that Jacob Chansley, right? Jacob Chansley is still in custody and is still on a no bond. This guy got out after about 3 weeks. So a little bit better, but still inexcusable. Now, he's out of custody on February 5th. On March 18th, U.S. government, they wanted a 60-day continuance back then on March 18th, right? And this might be a little bit reasonable. Why did they want this? And why are they asking for an exclusion of time? So they're saying, Judge, we need to violate this man's right to a speedy trial because of our problems here. We charged him with a crime. We're not quite ready yet to to continue forward with this. And we need 60 more days. And the judge might say, well, if you need 60 days, well, that's fine, but you only got 70 days. And so if the defendant wants to object and have his day in court, if he wants to exercise his right to a speedy trial, you're asking for 60 days, like I can give it to you, but that comes off of your clock. Those 60 days come out of your bin of time because the defendant wants his day in court and our Constitution says he has that right. So they said, yes, we know that 60 days out of our 70-day bucket, that's a lot of time. So we're going to ask, Judge, that you just exclude it. Just don't give us the 60 days. Just don't count that against us because of these extenuating circumstances, because we have so much additional stuff that we have to do. And the judge basically agreed. Said here, the government asserted that due to a number of individuals, the government meaning the prosecution, currently charged, the volume and the nature of all those materials and blah, 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 that a continuance was justified, right? This is what they said the first time. This is the government's argument. They came in here and said, we need more time, effective preparation. If you don't give us this continuance, it's going to result in a miscarriage of justice. We got too many interrelated charges. The investigation is ongoing. We need more reasonable time, due diligence, blah, blah, blah. Okay, you got it. Now, the defendant, that same day, back on March, says, no thanks. Okay, I have a right to a speedy trial, so the defense filed an objection. We oppose that. Say, nope, we have a constitutional right and a statutory right to a speedy trial, and we object to the tolling of that time. If you're going to give us if you're going to give the government 60 days, don't count it against us out of our time. It's not our time, it's their time. Defendant said that there was nothing complex about this case, which involves pictures of him with a bullhorn on the Capitol steps. So there you go. That's enough. Argued that the government mischaracterized its own logistical and manpower burdens, and that they were, trying to manage their trial calendar. So this is the defense argument now. He claimed that he was suffering emotional distress from the charges, of course, which were affecting his reputation as a public servant. Of course, they're trying to remove him from a committee. I think there's a recall going on of him. Observed that he could further suffer prejudice in the form of dimming memories and loss of exculpatory evidence. So the defendant is now saying, listen, no, Judge, we oppose that 60-day continuance request, and don't you dare hold that time, take that out of our bucket. That's our time. I have a right to a speedy trial. We are not waiving any of it. So if they want that continuance, that's fine, but then they got 10 days left because they used up their 60 days. And they're saying specifically, not a complex case. You got pictures of him in the bullhorn right outside the building. That's enough, right? Restricted area, you've got him there. And the list goes on and on. So the government now comes back. And, we give us a little bit more background here. So there was a hearing on April 7th. The court granted the government's motion. Okay, so the prosecutions comes back out in March, says, we're sorry, we need 60 days. Defense responds, says, no, we don't appreciate that. Judge comes back out and says, yeah, we're gonna go ahead and grant a 20-day continuance, and we're gonna toll the time. So it comes out of the defense bucket, or it doesn't count against the government. The government has all of their time still. At the hearing, the government told the court that it was still in the process of reviewing discovery materials back in April 27th. The government represented it would have expected a vendor to oversee the process by June based on a misunderstanding of information that had been made available to the prosecutor. The government mistakenly represented the vendor would actually be disseminating discovery materials in June. Court set motions, hearing on all of this stuff. Then in June, the court said, what's the status of the discovery? Assigned prosecutor stated, we could not provide a specific date by which the defendant would receive these materials, inadvertently leaving the impression that we had no explanation for our failure. The court then scheduled another date. The court, sua sponte, on its own, stated that it would not exclude time between June 30th and August 9th because the government did not produce its discovery. Okay, so this time now counts against. It would not exclude time. Then on January 26th, the government filed a memorandum regarding the status of discovery. The government now, as a preliminary matter, acknowledges its prior misunderstanding led to confusion. The motion is intended to clarify the record and explain the reasons that tolling is warranted. In brief, the government is committing to ensuring that all exculpatory materials are produced in a comprehensive, accessible, and usable format. All right, so what's happening here is they're asking for more time, and they're going to go through and they're going to try to justify it again on the basis of the same garbage that we've already heard, that there's so much discovery, that this is taking so much time, that we need more the whole thing. All right, so let's see what their first argument is here. It says the government's approach, this is so offensive even as a defense attorney, I can't even take it. The government's approach to discovery is intended to ensure that all arguably exculpatory materials are produced in a comprehensive, accessible, and usable format. Okay, so here what they're talking about is sort of formatting, right? We want to make sure that it's all produced comprehensively, accessible, and usable. Oh my gosh, makes my blood boil. All right, the government has always understood the magnitude and the complexity of discovery in January 6th. We've taken a very expansive view on this. As set forth in our prior memorandum, arguments, there were arguments that people support that they believe that they were authorized to enter the Capitol. Defense counsel in the Capitol breach cases have made requests for any and all information that captures an individual's defendant's conducts or statements, showing that people are peacefully walking around the Capitol and that members of law enforcement allowed people to enter or remain in the Capitol or on restricted grounds, acted in friendly or sympathetic ways, or otherwise failed to do your job. Given the charges here, this information might be relevant to the defendant's case. Of course, these many types, might be exculpatory. All right. So here what they're talking about is there's a popular defense going around that this is not trespass because the police were actually waving people in onto the congressional building. That we saw images of that. We saw video here of doors being opened and police from some entity saying, well, I disagree with you, but I respect what you're saying, or I disagree with you, but I respect your right to be here, and things like that. Many people, including Kash Patel, who we played a clip from his interview here on this show, saying that basically one half side, the back side of the Capitol building, was essentially left wide open. We've also had many requests for 14,000 hours of video footage from one of the most secure buildings, should be in the entire world. Evidently was not, because our intelligence agencies have dropped the ball on that one. But the point here is that there's a ton of footage that everybody's trying to get their hands on for many, many different reasons. But that is shifting the burden onto the defense to have to process all this. Okay, let's continue on because I'm going to get sidetracked on so many different angles. I want to make sure we make it through this entire document. To the extent that the information described above may exist, it may be interspersed among thousands of hours of video footage from multiple sources: Capitol surveillance footage, body-worn camera footage, results of searches and devices stored in Communications Act. We have parlor video. We've got unpublished news footage, multiple investigative documents. We've got witnesses, other subjects. As the volume of material makes it impossible for the government to review every potential discoverable item and determine its materiality, and because defendants are in a better position to determine what evidence they believe will help, it is our intent to provide the defense with all data that may contain such information, but in a manner that will facilitate search, retrieval, sorting, and management of that information. All right. So let's carry on. We have here, the motion continues. Having recognized from the beginning the unprecedented discovery obligations would inevitably be associated with the collection of voluminous materials relevant to many, if not all, defendants, and the need to provide the information, we hired somebody specifically called a Capitol Breach Discovery Coordinator to manage this project. They created this thing called a discovery team. It's going to augment its staff, and they're going to receive, track, process, redact, blah, 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 all of the information. They're training agents and attorneys, managing filter reviews. There's voluminous data. They're reviewing materials for discoverability, responding to discovery-related litigation, all of it. It continues to add staff as required to conduct Brady reviews. All right, friends. So this is where we get to the point where it's just like, are you kidding me with this now? We've talked about this before. The city of Scottsdale in Arizona, right down 5 minutes down the road from our office, processes 500 to 600 cases a month on a slow month. When we have big golf tournaments, or the Super Bowl comes here, or we have any big events, it processes more than that. Many of those are disorderly conducts and criminal trespass charges. You don't need every single piece of footage everywhere to go and prosecute a person, right? You need enough there to bring a case and convict them. The rest of that is up to the defense now to sort of, come up with a defense. That includes, getting access to exculpatory material. But there's something finicky happening here, and I want to show you what it is. All right, let me continue on here. The government moved expeditiously to retain a vendor to provide litigation support services. All right, so they went and hired somebody. We've seen a lot of this. They had a final bid, got over to Deloitte Financial Advisory Services, and it was retained on or about May 28th. The government began transferring data to Deloitte the week of June 8th. All right, folks, so you've got defendants now who are sitting in custody. The U.S. government didn't start processing the discovery, began transferring the data to this third party called Deloitte Financial Advisory Services on June 8th, 6 months after it happened. They just started on it. And then they come back in August and say, we need more time. So all of that evidence, all of that exculpatory material, any of that stuff has all just been floating around here a little bit. And so the government is going to tell us, well, we have to give you everything before we take action on your case. And the defense is saying, yeah, but we want a trial. We want a trial right now. If you have enough evidence to convict us, we want it right now. You saw that because in March they objected to the continuance the first time. The judge granted it anyways, and they're back here again asking for another continuance. They just started sending the discovery over for processing or whatever they need to Deloitte in May, and it just started transferring it. They just signed the contract in May, just started transferring everything over back in June. So for those prior 6 months, nothing's been happening. Processing materials, they're going to say, will facilitate... Processing materials in a manner that will facilitate review by the defense is particularly complex because of diversity of potentially relevant materials and the varied formats in which they are stored. Each category of video footage must be analyzed separately. For example, we have Capitol surveillance footage, thousands of hours stored in a proprietary format that would be extremely burdensome for the defense counsel to search and review. The solution to processing such footage will not be the same for processing body camera footage, different proprietary format. Different searches resulted, a device is seized. Okay, we are working with the FBI, Deloitte, Federal Public Defender, and other parties necessary, the developers of the proprietary formats at issue, to ensure. Folks, they're talking about, converting videos from one format to another. And that justifies just dumping all over people's constitutional rights and a right to a speedy trial. That is not the defense's fault. The fact that you have multiple different formats, VHS tapes that your idiots are banging into, things, it's not the defense's fault. That's your fault, not his. So don't, you're not doing anybody any favors. Okay. Determining the optimal manner of processing and processing itself, it takes time, but the government is taking all appropriate measures to expedite this task. Yeah, right. Notably taking the time, listen to this. Listen to this. This is why I underlined this line. Notably, this is the prosecutor. This is your U.S. government talking to the defense. Notably, taking the time to do this now will significantly benefit the defense in terms of its ability to review the information ultimately produced by saving the defense countless hours it would otherwise expend performing burdensome and time-consuming searches of such information once it receives it, given the nature and the volume of the materials involved. So it's so condescending. It's insulting. It's this idea. It's like, hey, we're going to charge you with a crime. We're going to hold this over your head indefinitely. We're going to override your objections to our continuances. We're going to we're going to tell the court that we're starting to start this process a lot sooner than we actually were. And then we're going to just ask for more time. That's also going to be dumping once again all over your Sixth Amendment rights again for a second time. But even though it's just your constitutional rights and everything like that, don't worry about those, because when you get the data, you're going to love it. It's going to be super organized for you. It's going to just be easy to get and like alphabetical, and like it's going to be color coded. There's going to be highlighters on there. It's going to be just beautiful. You're going to love it. And you say, well, what about my Sixth Amendment right? And they say, yeah, but it's organized now. And so now you can just go and search for it however you want. And so first of all, do you believe that for a second? Do you believe that the defense attorneys are going to get something in their lap and they're going to go, oh, thank you for organizing all of this. This looks perfect now. I can just type in my defendant, and then everything that you've assembled for me in your little spreadsheets, we're just going to go, oh, there it is. That's all the evidence. I guess we don't need to look through anything else again. Thank you, government. Thank you, DOJ, Mr. Prosecutor, for concocting whatever you think that you're making for us. You're making us a nice little lunch. We don't want to eat it. We don't care what you're organizing over there. I don't care what your discovery team looks like. If you don't have the evidence, you should not be bringing these charges, and you should not be asking for additional continuances. And this, we're going to see where this goes in terms of a ruling, but this is insane. Thank you for organizing your data. We don't want it organized. Nobody wants it organized. You have bring the charges or don't. And so they're just going to spin their wheels. More time until the government, until some judge with any stones comes back out and says, all right, enough of this already. Bring the charges or don't. As each category of data may present a unique challenge, the government cannot state with certainty when the transfer of the bulk of material will be complete, right? Cannot state with certainty. So in addition, Judge, in addition to 2 times now violating Sixth Amendment rights, we're also going to be not able to give you an answer. We can't even tell you when this stuff is going to come in. All right. However, as described above, the government is prioritizing the materials that are likely to be most relevant to the Capitol breach defendants. The goal is to populate the discovery database with at least Capitol surveillance footage, body-worn footage, and other materials from responding law enforcement agencies in approximately in the next 4 to 6 weeks. So they need another 4 to 6 weeks also, which is absolutely pertinent, right? Because they asked for a 60-day continuance. So. Okay, so that's what they've got now. We're not even currently done. Now, let's check this out. We understand that the defendant believes that he has... So here now the defendant comes out, right? The defendant is now saying, listen, okay, you've got all that discovery. Don't even care about it. Don't want it. Don't have it. Don't need it at all. We want to go to trial with the evidence that you do have. Let's go right now. Because we think that the evidence you have is garbage. We don't think that anybody's going to convict on this. You don't have it. You haven't disclosed it. You've got some procedural violations that you're making. There are other ways that you go about this. If you're a defendant and you're being charged with a crime, you need to know what they're charging you with, and you need to know what the evidence is. Now, if you are somebody that says, okay, well, they're not going to be able to disclose this stuff to me timely, that is a proper defense tactic to say they're not going to be able to produce it. Set it for trial, make them prove it. They show up to court. They don't have the evidence. Too bad. Trial's already started. The process is already underway. The government now says, sorry, Your Honor, we're not prepared to proceed. We have to dismiss the case. Happens all the time. Would happen in this case if the judges would allow it to, but we'll see what happens here. Now, so the defendant is saying, okay, I don't need the evidence. Look, I'll just go to trial with what I've got, with what you've got, because you've got nothing. So we're going to schedule it to go. The prosecution now comes back out and says, we understand that the defendant believes he has received all the information he needs to proceed to trial, like images and all of that other stuff. And that the only question for trial is about the conduct, which are just simply 2 misdemeanor charges. Misdemeanors, folks. These are misdemeanors. These are not even felonies, okay? So the next time somebody comes to you and says, yeah, but it was the Capitol building, you say, okay, well, it was a bar in Old Town. Yeah, so a misdemeanor for that, a misdemeanor for that. So what's the big deal? In this case, it's the federal government that wants to turn people into political prisoners and grind them into the stone indefinitely so that they have a political boogeyman and an axe to grind for the next 3.5 years. But anyways, it says, Brady says imposes a constitutional obligation on the government to disclose information that is favorable to the defendant where it is material to either guilt or punishment. Okay, so what they're saying here is Brady applies in any case where the defendant proceeds to trial. So the government is coming back out and saying, listen, I know you think you've got enough evidence here. I know that you want to go to trial. We can't let you go to trial because there may be evidence that we have in our possession that might prove that you're innocent. And if we go to trial and we don't give you the evidence that might prove that you're innocent, you might be convicted. And that's dangerous. So we can't go to trial, and we're just going to ask for a continuance for another 60 days that violates another one of your rights, and we're going to ask the judge to approve that and then not count any of that time against us also. But we have to do this for you. We're doing this for you, Mr. Defendant, because we might have evidence that proves that you're innocent, and we can't let you go to trial while we have that evidence. Folks, the answer is you dismiss the case then. If this were a reasonable prosecutor here, that wasn't trying to go after political defendants, they would say, you know what? You're right. We have some evidence that we have not disclosed to you. It might, in fact, be exculpatory. Exculpatory meaning it might show this man's innocence. The government saying, well, we have that. We might be able to show that you're innocent once we get all this organized for you in our little spreadsheets with Deloitte. Then we're going to send that over to you, and you're just going to be able to search for your own innocence. And you're going to be able to trust our assembly and our manipulation of our discovery packet to whatever you know. Okay. That's what they're saying. They're doing the defendant a nice favor. Okay. Now, regardless of the defendant's current position regarding the discovery, the government maintains an obligation now to help. Okay, that's so nice of them. For all the reasons above, despite our diligent efforts, we are not currently in a position to identify all the information that may be material to the defense in this case. Okay, can you see that, folks? It's been 8 months. It's 8 months now, and this isn't a government motion that went in the court docket today. Despite our diligent efforts, we are not currently in a position to identify all information that may be material to the defense in this case. That's exculpatory evidence. If that's the case, well, they should throw it right out. We do not know the theory of the defense, and to the extent that we can surmise what it might be, relevant evidence may be interspersed among voluminous data and we cannot possibly review in its entirety. Okay, well, do you have enough to bring charges? Yes or no? You did. You brought charges. Now, when they said that they wanted to go to trial, you said, oh, no, we need continuances so that we can continue to do our work. All right, now how about this? Further, we are not in a position to turn over the universe of information we possess either. Okay, so here's what they're saying. We have a lot of evidence here. A huge bucket of evidence. In that bucket, some of it might prove that this defendant is not guilty. But we can't tell you what evidence in there might show that. And we can't give that to you either, because we don't know what it is. It's in the bucket. It's messy. We can't find it. We're digging around in there. We can't find it. Okay, so the defense says, that's fine, no problem. How about this? How about you just give us everything and you let us look through it, because we can find it. Government comes back and says, oh, no. Well, we can't do that either. Furthermore, we are not in a position to turn over the universe of information we possess for the defendant to review. So we can't tell you what evidence might show that you're innocent, and we also can't give you the entire bucket to look through on your own. Sorry. Then we get to this very curious sentence here. It says, although we are aware that we possess some information that the defense may view as supportive of arguments that law enforcement authorized defendants, including the defendant, to enter the restricted grounds. For example, images of officers hugging or fist bumping the rioters, posing for photos with rioters, moving bike racks. We are not in a position to state whether we have identified all such information. Can you see what's going on there, folks? The government is acknowledging we are aware that we possess some information. Now, doesn't say what that information is, but it does say that that information is information that the defense may view as supportive of those arguments, that the police were in collusion with whatever was going on, right? It's essentially that police and law enforcement were sort of involved in the whole thing. And the defense there is, if the police invited you onto restricted grounds, that's not trespassing. If you're protesting and the police invite the protest into certain restricted areas, that's not disorderly anymore. That's an acceptable protest. You're on the outside of the restricted grounds, your protesting is just protested behavior. When you cross that line onto restricted grounds, now you've got two crimes. One is violating restricted grounds. The other is disorderly conduct, because you're being disorderly on the restricted grounds. But if they invited you onto the restricted grounds, there's no trespass, and your continuing protest is no longer disorderly. So the government is acknowledging that they've got something, don't know what it is, but they've got some information that on first glance that they say the defense may view as supportive, that police were posing for photos with rioters, moving bike racks, hugging, fist bumping, posing for photos, right? All of it. We are not in a position to state whether we have identified all such information. So it's floating around in there. It's also in that bucket. And so they're saying, because of Brady, we're required to make available the voluminous data that may contain any similar information for the defendant to review. Yeah. So they're going to make it available whenever they get around to it. It's August now. They still have no information. These two U.S. attorneys here say, for the reasons described above and any others that may be proffered, the government wants the court to grant its motion for a continuance. They want their 60 days, another 60 days, for 60 days in order to provide complete discovery. They want to further exclude the time, so make sure it doesn't count against them under the Speedy Trial Act, on the basis of ends of justice are now served. That justice is served by taking these actions. They outweigh the interest of the public and the defendant in a speedy trial here. U.S. government saying our botching of this entire discovery thing for the last 8 months, we need the time because our interests and the interests of justice outweigh the interests of the public and your right to a speedy trial, or the defendant and his right to a speedy trial. Further, for the same reasons that support an ends of justice continuance, we request the court exclude from computation the time that has elapsed since June 30th. You see that, folks? So they also, because the judge gave them a no-no. They said that time from June 30th to August, that counts against you. They're saying retroactively that the judge should also exclude that other time from June 30th now. They want 60 days, and they want the prior continuance of that time that counted against them to be thrown back into their bucket. Oh, get that time back. They want to exclude from the computation of time under the Speedy Trial Act the time that has elapsed since June 30th. What a stinking joke. Oh, my goodness. Who signed these here? We got Emily A. Miller here, Capitol Breach Discovery Coordinator, and Janani Iyengar over there, U.S. Attorney's Office, both prosecutors. Oh, my goodness. Just the worst. All right, let's take a look at some questions over from watchingthewatchers.locals.com. I almost couldn't make it through that segment. I mean, I'm just like so hot under the skin over here. It boils my blood because this stuff is so obvious, and it is getting away. They're getting away with it right in DC, in the DC circuit courts. All right, we got some super chats that came in, and let's take a look at locals first. Over here, Kenny1B is here, says, it's pronounced Couy Griffin. I'm from New Mexico. Met him. Very nice, God-loving man, kind. He ran the Cowboys for Trump rallies where they rode horses around carrying Trump flags last year. They were carnival-like rallies. Thank you for that, Kenny1B. We've got have nothing to say. Somebody says, have nothing to say, but have a good week. Thank you, sir, or ma'am. 3 Girly says, I know that some points that they can sign away their right to a speedy trial. What happens when they do that? Does that mean they have unlimited time to bring it to trial? So, yes, if a defendant... So typically judges won't allow that to happen, right? Judges they don't want cases on their dockets indefinitely. So we rarely see cases go, longer than that's not true. Cases often go a lot longer than they need to, but judges will typically put an end date on that. So what happens when they do that? If they waive their rights to a speedy trial, then that time it doesn't count against them. And so I think Jacob Chansley, his lawyer actually waived that time and said that that's okay. We don't want it to count against us anyway. We have Kenny1B says a New Mexico AG tried filing animal abuse charges against him for riding his horses. Also an elected county commissioner in southern rural New Mexico. Thank you for the bio there. And I think they're trying to recall him from that commission. I saw a headline about that. No Doubt is here, says, bringing up the court documents, explaining what they mean and pointing out how it should work if they are not incompetent is why I watch your channel. Keep it up. That's from No Doubt. Thanks, No Doubt. And I got a little bit flustered on that one. I get so stinking mad. I was like, Rob, take it easy on this segment, but oh my gosh, it's so frustrating. Sergeant Bob says, I love the depth on the case. Of course, I'm a law junkie. The devil is in the details. Somewhat related is U.S. Code offense of lying to the FBI. You and I both know that crooks lie to the police. Police try to disprove the lie. It goes on and on. It's part of a game. Why has a court not thrown out this law? The interviewee is not under oath at trial. That I would understand. For this reason, I would not speak at length with any federal agents who appear at my door. Interacting with law enforcement is important, even for old retired cops. You go, man. Thank you, Sergeant Bob. Yeah, it's good to have you in the house. It is a bit of a game. Yeah, it is a bit of a game, and it's unfortunate. Now, I say a game because it's sort of human nature to game things. But when we talk about stuff like this, it is so reprehensible to me that we have prosecutors like this who just continue to practice law this way. It boils my blood. All right, we got Vienticus Prime says, what is the legal recourse for these people that are going under this miscarriage of justice? How much do you think there is a legal expectation of such actions by the people receiving unfair treatment? I've been toying with the notion that it's expected for these people to sue the government afterwards, just to blame them for the government not having enough money in the future. Look, there aren't many. There's not much recourse here, right? They are in the criminal justice system right now. If this current judge doesn't, if this, like, for example, if this judge comes out and grants a continuance, which I can't imagine that he does, if he says, yeah, 60 more days, if the judge does that, I'll be surprised. But if that happens, right, the only thing that this attorney could do is what's called a special action, basically try to pull that case out of this level and appeal that specific ruling, right? So you could take that ruling out, take it up to a higher court and say, look, it's sort of like an appeal, but not for the final conviction of a case, just for something that happened in the process of the case. So if you go to trial and lose, like Derek Chauvin, he's going to appeal that. But if in the pretrial process of the case, Derek Chauvin lost a continuance motion and he said, no, that we should have gotten extra time on that. Judge, I need a continuance. And the judge said declined. Eric Nelson, his defense lawyer, could have said, well, we think we should have been granted that. We're going to appeal it up to the higher court. And then the higher court would rule on that issue. Now, if it was something that was consequential, that could come back down and change the course of the underlying case, right? Like in this case, if this goes up to an appellate court and the court says, no, you don't get a continuance here, trial's Monday, see you Monday, then the U.S. government would necessarily have to dismiss the case against them. It's a good question, though, but it's problematic because if the judges don't do anything, well, they're out of luck. We got Thunder 7 says, Rob, can't any of these defense lawyers use Kavanaugh's storming of the Supreme Court as a comparison to how the insurrectionists were treated? You mentioned before that they got small fines and no jail time and what about the BLM attacking and burning federal buildings? They serve no real time, no damage there. This is a double standard. Can anything be done to bring justice to them? So Thunder 7, it's a good question, right? Each case is individual. Each case needs to be individual because people have different backgrounds, different criminal records, different criminal history. I think a lot of the time people try to lump criminal defendants into the same bucket that you might get in a class action, right? Where you'll get somebody where there's a drug that goes out or something malfunctions in a car and everybody gets impacted by that. And so you get thousands of people and you lump them all into a class and the class can go file a lawsuit on behalf of the class. In this case, these are all individual defendants with very, very different backgrounds and different posture in their cases. And so the idea that there could be something done uniformly, I think is a stretch. Now, each one of these people can, of course, work on their own cases individually, and we'll see what happens with those. All right, we got K Bean. Let's go over to YouTube, take some super chats. We got K Bean in the house, says Couy Griffin charged with misdemeanors. Yeah, not felonies. They were misdemeanors as we got to. You probably sent that before we got there. I didn't even know it, but yeah, misdemeanors apparently from the court documents. Patrick says, at what point can all this be thrown out on speedy trial grounds? Well, it sounds like, Patrick, that's what what the judge had previously sort of, they were toying around with this idea. The prosecutor came back, they filed a request for a continuance. The judge said, well, you don't get 60 days. We're going to give you 20 days and we're going to count that time against you. Now the government is coming back and saying, well, we really don't want those other 20 days to count against us either. Can you give us those days back, please? And then give us another 60 on top of that. And so, here it's, where did that one go? So if a judge now then enforces the speedy trial rights and the government is not able to comply with those, then at that point in time, the government has no choice but to say, we are not ready to proceed, and they have to dismiss the case. Or the defense files a motion and the judge dismisses on that ground. A great question. We have I am flag is here. Says, Rob, can you please inform the government that there are free websites that converts video files? Yeah, it's not complicated, right? And it's, I think handbrake.fr is a good one. I think that's a website. Thank you for that, I am flag. Not super complicated. We have Umar says, isn't Deloitte a big tech search engine partner? I wonder what IT tools may come out of the evidence processing Deloitte Financial is conducting. It's a good question. I don't know. Again, I don't know what's so complicated about it. But I think the answer is there isn't all that much that's complicated about it. Mike Lindell is over here. Let me stop this spamming action going on over here on YouTube. I'm gonna go ahead and do that with that person. So get rid of them over there. All right. Let me double check that. There we go. Got that person taken care of. All right. So now, what was I saying? Let's go back to the questions. Super chats. Deloitte, is it a big tech or evidence processing? I don't know. I really didn't look into them at all. But I don't really know why a financial company, Deloitte Financial, is doing criminal discovery in federal insurrection cases. But all right. We have Umar here. Says, nope, already got that one from Umar. We got Mr. Wait, no, that's another question. Umar said, isn't Deloitte partner a search engine? If so, they'd essentially have a hand in the big tech space and now the government through the evidence processing. I know, so that's a little bit of a different question. Well, they would certainly have access to all of the discovery, right? 14,000 hours worth of data. Whoever got that contract, right? They have access to a lot of evidence that even the defendants don't have, that even the American people don't have. Many people have been smashing the desk saying, where's the 14,000 hours? Where is it? Don't know. They got it. Mr. Ted Offensive says, I was there on January 6th. The cops were letting people in. I did not fall for it because I generally don't trust cops. It's a good rule. Generally speaking, is a good rule. We have Beth Coddington in the house. Thank you for that, Mr. Ted. Beth says, hey, Robert and all, obviously the defense isn't paying the judge. It's the prosecution. Just kidding. I appreciate your passion on this. It's enraging. Thank you for your thorough coverage of this. Thank you, Beth Coddington. Always with the very generous super chats. I love all the super chats. Beth, you're very much appreciated. Thank you for the question. I agree with you. It is enraging. Oh my gosh. Blood boiling level 10 over here. All right. We got some more over here. From Deputy Premier Beria says, show me the man and I'll show you the crime. That's right. We're going to do that in our third segment today. Obama is in deep trouble. We got 3 girlies in the house. Says, when I worked security, we had to provide the police the video surveillance footage. We had to record it from our system and make it accessible for the officers. The officers' job is to provide that footage no matter what the format. Why are the prosecutors even involved in that? It sounds like a big excuse to me. You're right, it is. How is the government transferring data to a third party the defendant's fault? That makes no sense. That's the defendant's fault for the discovery not being sent over until June 8th by a third party. Why should this be excused by any judge? Shouldn't have the judge look at this and call this hogwash? We'll see. Can't the defense attorneys look through this material? God, Ashley Babbitt's over here now on YouTube. Let me put a stop to that also. We're going to go ahead and get rid of that person. Says, can't the defense attorney look through this material without having it categorized by the prosecutors? I mean, I guess it would be nice if they did that, but is it necessary? No, it's certainly, I mean, it's nice, but it's like, nobody cares what the prosecution says, right? They send us over their discovery and we say, okay, that's great. Thank you for your nice little packet of garbage. We're going to go talk to the officer ourselves. We're going to go to the scene and investigate it ourselves. We're going to talk to the witness ourselves because the evidence that you put together for us, that's okay. Thank you. So it's a joke. The whole thing that they're organizing all of this for us. If you're a defense lawyer that just gets the discovery file over from the prosecution and you're like, oh, good. Well, thank you. Thanks for giving me everything here in our case, and we're just going to go through this, and I guess we'll just prepare our defense based around whatever you told us happened, and so that's the end of that, right? No real defense lawyer is sitting there going, oh gosh, that's great. I'm really glad that they're stalling on this and taking their sweet time to organize all the data that I'm not going to trust anyways. It's meaningless. It's an excuse. The whole thing's an excuse. It's a joke. We have hey, Leafy Bug, you got to save that question for the next one, for the next segment. We've got Miss Lucky says, Rob, I think the government will only pass on what they want. They are hiding something. I think the defense attorney is smart enough to figure this out. Yeah, he's on it. He's objecting, which is very, very good. Good to see you, Miss Lucky. We've got Hunter's Crack Dealers in the house. Says, after living and doing work in Russia for many years, people now have more rights in Russia than they do here in the U.S. I know, it sort of feels wild. You're going, man, at least we don't live in China where they're locking you down and limiting what you can say on the internet. Everybody's going, oh, I guess we're living in China now. Welcome to the USA 2021. We've got Mama Rock says, Rob, I love the passion you have for the defense of the law. Thanks, Mama Rocks. Mama rocks. Mama does rock. I know that for sure. We have Phil McCracken says, any countries left with the rule of law? Phil McCracken says, any countries left with the rule of law? You know, I don't know. I'm not sure. If you find one, let me know. I'm interested. We got Leafy Bug. Let me see here. It says, no, Leafy Bug. That's the next segment. I got to come back to you on that one. We have over here, Three Girlies says, so if the defendant was convicted, couldn't they appeal on the grounds of prosecutorial misconduct? That they didn't provide discovery. Wouldn't this motion be proof they failed to provide the discovery? Also, couldn't they appeal on the idea this is violating the Sixth Amendment? That is from Three Girlies. Yeah, so I think you're absolutely right on all of those different things, Three Girlies. We can see that prosecutorial misconduct, I think, would be something where if they got a little bit more, I think we need a little bit more than that here in order for there to be some allegation of that. Now, I think that these are all certainly cases where that is a thing, but in other words, where prosecutors are intentionally being overly aggressive with the January 6th defendants. In my mind, that is a political prosecution. That in of itself is prosecutorial misconduct. But you can't really prove that right now, right? All they're doing here is they're still latching all these excuses onto something that is somewhat feasible, right? A judge could take a look at the case or this situation and say, yeah, you're right. There are 14,000 hours. There are 535 defendants. For a Washington, D.C. federal district court judge, yeah, this is like the crime of the century. Right? In Scottsdale, we have many judges that can handle this no problem. 500 defendants. Yeah, we got 3 judges over there. I'm like, that would easily go, no problem at all. Bring them in here on Thursday. I'll run through them all, because that's how many cases they run through regularly. And this person over here on YouTube. All right, let me see. All right. So prosecutorial misconduct, wouldn't they be proof they failed to provide the discovery? Couldn't they appeal on the idea of violating his Sixth Amendment? Yeah, so if the judge did come back and find against this, then in my opinion, that would be worthy of an appeal or a special action or something similar. Good to see you there. Lauren S. says, thanks for the breakdown. No extra questions today. You covered everything. Just curious about during the segment. Happy Monday. That's from Lauren. Good to see you, Lauren. We have Cove Queen is here. We got a lot of Barack Obama questions. We got to get to that segment here. Sergeant Bob says, didn't mean to minimize the instant case. Very serious. I do get it. Yeah, no, Sergeant Bob, I didn't mean to imply that you didn't minimize that or intend to minimize that. I totally gotcha. Soul Viking says, disgusting actions once again on the part of the government, and still few, if any, words about the unindicted co-conspirators. Yeah, we're going to see where that goes. We got Leafy Bug is saying, do you think AGs and the DAs should be directly elected positions? It seems to me that this could be why prosecutors are so crazily politicized in the U.S. Should be, are you asking if I should? So they are, right? So in Arizona, ours is elected. In the U.S. government, our attorney general is appointed by the president. So, you can sort of see 2 systems at work there. I'm not sure one is necessarily better than the other. I do certainly think that local is better than federal. And a lot of the problems, I think, probably with these cases are coming from sort of the prosecuting of these in federal courts, where these are naturally, if misdemeanor offenses are dealt with in local state courts. But DC is its own little beast, right? If we had 535 trespassing cases or whatever, we would have no problem with that in most localities. Your city courts can handle all of that. So, all right, we're going to get rid of that user as well. All right, so great questions over there. Let's see. I think we saw a couple of the super chats come in. We had Angela B. is saying that Matt Braynard is leading a rally for equal justice of January 6th detainees at the Capitol on September 18th. Wow. That's amazing. I know Matt. I don't know Matt Braynard, but I know of Matt Braynard. I don't know him personally, but he did a lot of work on the election. Seems like a pretty brilliant guy. That's pretty awesome that he's doing that. I'll have to check in on that. We have over here, Ben Dover's in the house, says Dems need a good Judy. Don't know what that's, I don't know what that means, so I'm going to be careful on that one. But good to see you, Ben Dover and Angela B. Beth Coddington. We have, I think that was our last question over here from watchingthewatchers.locals.com, and I want to thank you for all of your support and your encouragement and love on this segment. It's very infuriating. We're not going to see more of this, I think. We're going to see continuations of this into the foreseeable future. If you want to be a part of the show, watchingthewatchers.locals.com. All right, so we're going to move on now into the next segment of the day. Do a little bit of a reset over here, make sure everything is looking good. All right, what do we have? Oh, yes. The fleeing Texas Democrats, the weapons of mass destruction carrying COVID aboard airliners flying into the Capitol, well, they are now suing the governor of Texas. They're very mad at him because they left Texas, so they're unhappy with the consequences of their actions, and because they voluntarily left the state, causing some problems for them, somebody's got to pay for that. Who? Governor Abbott and some other people from Texas. This is the lawsuit. Very interesting lawsuit. We're going to go through here. Not very long. You can see 7 pages. So this is going to be a fun one. And you can see the different plaintiffs over here. So these are all the fleeing Texas weapons of mass destruction COVID Dems. We have here Senfronia Thompson, Trey Fisher, Gene Wu, Vicky Goodwin, and many others. Not going to read all the long list of disasters. Now, who are they suing? They are suing the governor of Texas, Gregory Wayne Abbott, and Dade Fallon, along with James White. And so you might be asking yourself, well, who are these other 2 people? Governor Greg Abbott, of course, is the governor of Texas. These are the COVID Dems. You can see this was the little jet airliner COVID missile flying into Washington, D.C., 0 masks on, just really enjoying their breakthrough infections. And so they're suing now, as you can see. And interesting first thing to note is that the legal name of Dade Fallon, who is the Speaker of the House over there in Texas, they sort of used his kind of non-legal name, Dade Fallon, when his actual name is Matthew McDade Fallon. And so this is actually Matthew McDade Fallon over here. And so you look at stuff like this because it kind of stands out at you, kind of feels a little bit sloppy. So let's see what's going on here. The gentleman who drafted this complaint, Craig Anthony Washington, we can see over here, and we can also see that he sort of signed off on this here. Payer name here is Craig Washington. You'll notice that this lawsuit actually cost $402 to file there in federal court. And so he filed it, Thompson et al. Versus Abbott et al. Craig Washington signed over here. He's actually got an article on Wikipedia. He was the U.S. member House of Representatives from Texas's 18th district. And so he is filing the lawsuit on behalf of the Texas Dems. You can see Civil Rights Act violation signed off on here. Quick other thing to note on this. Now, a couple things happening that are a little bit questionable here. So first and foremost, you'll notice that he signed off on this from the Craig Anthony Washington law firm, right? Which is his law firm. Says that he's the attorney for the plaintiffs. But then he also says that he's of counsel down here, and he's working with this law firm here called DeGuerin and Dixon. And he's got an email address that says caw@deguerin.com. Huh. Okay, so if he's filing this from his personal law firm, then why is he using the firm down here, DeGuerin and Dixon, and then using his email address, deguerin.com? Maybe that's not a big deal. Maybe it's not even a thing because he's of counsel, right? He's of counsel. And so we have people who are of counsel here at our firm. They kind of come on to do work here and there. And so he may have been just sort of, mixing and matching some stuff, but it is a little bit questionable when the actual firm that is in Texas doesn't have him on their website either, right? And he's using their email address. So we got Dick DeGuerin, we got Lewis Dixon, we got Kathleen Bean and Mark White. Huh. Well, that's interesting. So there may be some of counsels over there that are not actually on the website. Also not that big of a deal, right? You might have of counsel come and go, but he's of counsel for a law firm that does criminal law, which are my people. Shout out DeGuerin.com. They do homicide, murder, sex offenses, vehicular homicide, conspiracy, drug prosecutions, and all of them. So why is this guy then, who does criminal law and of counsel for a criminal law case, filing a civil rights claim for the Texas COVID Dems? I don't know. Well, let's learn about him. So he was an American lawyer, Democratic Party politician, served in the Texas State Senate, U.S. House of Representatives. Son of some other people, career. Began electing members, elected Democrat to the 101st Congress. Oh, since leaving Congress, he's practiced law in Houston and Bastrop, Texas. Okay. So now we know about the guy. Let's dig into the lawsuit, shall we? Here it is. We got another typo to start things off. Introduction. And if you've been around this channel, you'll notice that this just doesn't look like a federal lawsuit, like at all. Doesn't even look like any, it doesn't. I don't know what's going on here, but it's not a federal lawsuit. Okay, plaintiffs will show that the defendant Abbott, okay, so here, a typo there, Fallon and White, they embarked upon a course of conduct which is intended to violate state and federal constitutional rights. What are they complaining about? Denying rights under the First, Fifth, and 14th Amendments. So, number one, race. They're saying that the plaintiffs here are either black or white. Okay, certain plaintiffs are either black or white. And you just look at it. So this is their class photo that they took, I think, prior to leaving. So yes, I think there are certainly some black or are either black or white, like one or the other. Okay. Nobody in between. Well, you can look at the photo. I don't need to have commentary on that, but this is their classroom photo that they took. Remember when you took one of these like in fifth grade? Like my fifth grade teacher was Mr. P. And so Mr. P had me, I think I was sitting like right here where this lady was in my fifth grade photo, but the Democrats took their own fifth grade photo. Now, their lawyer says that because some people are either black or white, and because their creed, he says that certain plaintiffs have expressed faith or a belief that every eligible citizen has the right to vote, which nobody's arguing. Eligible citizen, I think, is the key phrase there. And color. Certain plaintiffs are distinguishable based upon the melanin in their skin. Oh, okay. And then subsection D, why these why these rights are being violated. Natural origin. They are descendants of persons born in other countries. Okay, so race, creed, color, and natural origin. So this, this lawyer. Okay, so we have some black or white people here, and they are distinguishable based on the melanin in their skin. So that's great. Once again, all the plaintiffs, all coming out of Texas, all the Democrats, we know who they are. Here we have paragraph 3. Why is this civil rights claim valid now? Plaintiffs victims of a discriminatory, or must be are victims. Plaintiffs are victims of a discriminatory scheme to violate their constitutional rights to assemble, to redress grievances, speak, vote, travel, persuade members of Congress to help support them in their quest to obtain and maintain all of their rights, all because of their protected status. So, okay. Number 4, this suit arises out of deliberate acts of status discrimination, as well as discriminatory policies, customs, practices perpetuated by Governor Abbott against them. And the putative class is like writing a class action lawsuit that have disparately impacted all persons of each individual plaintiff status. The claim in this suit also includes damages resulting from actions taken. Okay. Defendants collectively acted in concert with one another under the color of law. So the governor and the Texas House of Representatives, yeah, they acted together in concert and under color of law as the governor and the House of Representatives to cause harm and damages alleged in this suit. Violates their rights, First Amendment right to the petition for government. So I guess they're saying plaintiffs request a class certification on behalf of others similarly. They are actually talking about this as a class action. Some plaintiffs also individually complain about retaliatory acts, threats, attempts at coercion related to exercising their First Amendment rights. So, folks, it's really hard to tell you what he's saying here because he's not saying much of anything. He's sort of regurgitating a bunch of constitutional language, which I love. I mean, it's a brilliant document. I appreciate him using it. Regarding the redressing of grievances, the right to speak and vote and travel and all of that stuff. Then he goes on and says this is all being perpetrated by the defendants against the plaintiffs, but we don't really know why or how or what the problem is. Or what is he complaining about? What did they do that is infringing on their right to free speech or free association or any of the other complaints? I'm not really sure what they're talking about, but in there. All right, let's see if we can figure this out. Jurisdiction and venue will fly. Oh, by the way, this was the Miller Lite photo. So this was when they were all sort of very, very sadly fleeing their state. The Texas Dems with that Miller Lite. Forgot about that one. This is a U.S. Code, House of Representatives. We have the plaintiffs and the different Texas Dems. Oh, we have different categories here. So in the first one, we just had black or white. Now we are adding Asian, Hispanic, gay, and all subscribe to the belief that citizens should be allowed to register and vote in all elections. Again, nobody is contesting that. I don't know what the problem is there. All right, so let's see what they're complaining about. Here is COVID WMD Texas Dem with Kamala Harris. You remember that was before she got rushed over to Walter Reed for some bizarre reason. So the Texas Dems, they're saying that they embarked on they're saying that Governor Abbott, they were trying to deny, coerce, threaten, and intimidate the COVID Dems to stop them, prevent them from voting in all elections, from peaceably assembling to address their grievances, to speak publicly about their constitutional rights, to associate, to be secure in their person. Folks, he's just going through and he's just, I guess, reciting what the First Amendment has to say. Plaintiffs allege that in doing the acts and things complained of, which, again, not real sure what those are specifically, like what? The defendants were conspirator engaged. The defendants were conspirator engaged in a scheme and conspiracy designed and intended to deny them of the Constitution. They allege as a direct consequence and a result of other acts, they've been deprived of liberty for a substantial period of time. They've suffered much anxiety and distress over the separation from their families and much discomfort and embarrassment of their reputations. Impaired, they've lost much time from their homes and the companionship and the care of their families. They've been required to spend substantial sums of money and of time traveling to and from the state of Texas to persuade Congress to pass laws to ameliorate the harms done and to redress their grievances. Folks, that sounds awful. They look, first of all, look at this. That is just horrible. Look at all that grief in her hair. This lady's hair is turning blue. That's how upset she is. All right. So what do they want for all of this? $5 here in actual damages. And they want the classes they represent $10 in punitive damages. Oh, okay. So $5 in actual damages and then $10 in punitive damages. All right. So here's what they're going to be asking for. They want to advance this cause on the docket, grant a temporary restraining order, order a hearing on the request for the injunction, grant an injunction. I don't know what they want injuncted. I don't know what they want an injunction for. Enjoin the defendants from doing any act that violates their constitutional rights, grants plaintiffs reasonable attorney's fees, actual and punitive damages. Here, signed off on by this guy, Craig Anthony Washington. Folks, I don't even know what to say about this lawsuit. I mean, honestly, I think it's kind of a joke. I think he might be joking. Yeah, I'll file that for you. Yeah, give me 5 minutes. Let me just see what I can just smash on this piece of paper together. We're going to call it a civil rights case, a class action. We want multiple injunctions for Lord knows what. The defendants did all sorts of heinous things that are not delineated in the lawsuit. It's a 7-page lawsuit that's asking for $5 in actual damages and then $10 in punitive damages. I don't even know if this guy, did he get their permission to file this? Did anybody look at this document before it went out the door? If an of counsel from our firm filed this, they would no longer be of counsel at our firm. So I wonder what the DeGuerin law firm has to say about this guy using their email address. Uh-oh, not too good. All right, let's take some questions over from watchingthewatchers.locals.com and see what came in on this one. We've got Want to Know says, I think the Democrats went to their own public school system because they can't spell correctly. Probably graduated with honors. Good to see you Want to Know. Leafy Bug is here, says, maybe they were cut from the Obama birthday party list because of the bad press they attracted. They're very, very angry about that. And someone has to pay. Yeah. Yeah. Did they get invited to Barry O's party? I didn't see him there. Probably pretty upset about that. All right, it's good to see you. Leafy Bug. All right, we got some other ones here. We've got Barack Obama's in the house. Says, booyah, celebrating. That's for the next segment. We're going to have to queue up. We're going to have to go back and queue up some of those. Barack Obama's, he's antsy. He says, Rob, didn't you know the amount of melanin in your skin directly determines your ability to acquire photo ID. Forgot about that. Yeah. Yes, this statement is anti-racist. If you think people with high melanin content have equal capabilities as less melanated individuals, you are racist. Melanated. That's a great point. Yeah, a lot of melanation happening in these parts. You know, I don't know. Okay. All right, I got to get it together here, folks. We have a whole nother segment to get to before we get to Barack Obama. All right, we've got Todd Trout says, did he write that lawsuit with a crayon? We're about to get into giddy mode over here. Thank you for that, Todd. We got Southern Democrats created the KKK is in the house. Says, are the Texas Democrats suing under 42 U.S. Code 1983? Yeah, they are actually. No, I don't know about that. Otherwise known as the Ku Klux Klan Act. What a bloody joke. The civil rights laws for when people like the KKK intimidate black people and attack them, not the governor enforcing the law about representatives needed to be present. Yeah, he filed under 1983. That's the civil rights statute. I don't know what civil rights were violated, but you're right? It's a joke. And that attorney, I'm not real sure what's going on here. We have Legal Eagle is here. A huge lawyer, YouTuber. Very bright man. Says, pro tip to the person who wrote the complaint, remove the oven mitts before starting to type. Otherwise, great job, and I'm sure you will win this case. That's from Legal Eagle. I really doubt Legal Eagle is on this post, but go check out his channel if you're into that. We've got another one. Sergeant Bob says, I taught high school 6 years, grade A for creative writing. There you go. Articulating legal foundation and justification for legal action. Grade E, failure, remedy, remedial education via demotion to non-legislative role. That's great. Thank you for that, Sergeant. You, sir, that's a bad lawsuit and you should feel bad. And you're now in timeout. You do not get to practice law anymore for filing that and paying $406 to get that filed in a federal court. Sit there and think about what you did, because that is not appropriate. We have Vienticus Prime says, just remember, politicians are elected because they are popular with someone. Yes. And we have over here, Thunder7 says, can Governor Abbott countersue for causing distress to the American people when they sang at the Capitol? So he could probably countersue them, certainly, but probably not for that. That would have to be brought under probably a federal action for cruel and unusual punishment to the American people. We need a constitutional amendment for that one. We have Jeremy Matrita says, Rob, the Democrats that fled their congressional duties to avoid the job they were hired to do, that plaintiff fled their duties freely without being stopped or prevented from leaving. The Democrats are only making themselves look like morons. Yes, the defendants also have the First Amendment right to make statements of frustration. The people who voted these politicians into office should be suing their representatives for abandoning their duties. Yeah, I think they're going to pay pretty significantly at the ballot box the next go around. Good to see you, Jeremy. No Doubt is here, says, maybe CRT is right. Race is the root of all. Well, I'm not going to read that. I don't know what that means. We have here, says, screw the Texas Democrats, says, since when do those Democrats care about the First and the 14th Amendment, since they advocate censorship on their political opponents as well as advocate for open racism via CRT? Remember the time when Gary O'Connor called Tim Scott? Did he call him that? Yeah. It required Alan West to send cookies, Oreo cookies, to the Democrats, and significant public backlash. Oh, man. That stuff is just, yeah, that's offensive. Oh, you know, the race stuff. All right, let's go over to, let's go check out the super chats here on YouTube before we get into our final segment of the day. We have here, this one is coming in from Mr. Ted Offensive, says, Dick DeGuerin is a famous attorney here in Texas. He represented David Koresh during the wow, really? Wow, that's amazing. The 51-day standoff with the Branch Davidians in Waco. 84 people were killed, 24 children. Again, a big reason I generally don't trust the police. Dick DeGuerin represented them. Wow. Such a fascinating story, Waco. That's one of those stories that I remember watching sort of as a young boy, and then it's stuck with me ever since. And I honestly think, Mr. Ted Offensive, that incident also helped to shape my political opinions watching that, because I saw what happened, and it didn't seem right to me even as a boy. We have, let's see, Newbie of Death Reviews stuff says, Miller Lite is better than Coors Light, to be honest. You know, it's been a long time since I've had either one of those. And back during my drinking days, didn't really even care. Just throw it in there. That's all that mattered to me. So I'll take your word for it. We have Curtis Bartle says, thank you, Rob. And all we can see how they are trying to take America down. Keep up the great reporting. Thank you for that, Curtis Bartle. We have Ben Dover here says, we need Howard the Duck to return. I don't know who that is, but sounds probably better than whatever we've got. David Elkins says, can they be fined or otherwise be punished for filing a frivolous and incoherent lawsuit? So yes, actually, right. So the judge could come back and say, this complaint is so bad, you know, I'm just going to it wouldn't be necessarily punished in the form of like, we're going to disbar you and not let you be a lawyer anymore. Wouldn't be anything like that. But the judge might just say, this is not even a facially sufficient complaint. In other words, it's not even good enough to get on my desk to look at because it's missing all of the things that we need in a lawsuit in order for it to be sufficient. So that would be a punishment, right? And keep the 402. This has been ineffective. It's been dismissed. You're not a good lawyer for filing that. Don't do it again. And that would probably be the extent of it. The bigger consequence might be from DeGuerin saying, why are you using our emails in your garbage motion? We don't want to be associated with that. What are you, nuts? So he might get in trouble with them, or maybe he won't. Who knows? Maybe they endorsed it. I don't know. Good to see you, David. Thank you for that. We have Angela B says, me and my coworkers are spontaneously going to Honolulu to protest mistreatment of Hawaiian turtles. Hope my employer doesn't violate our civil rights. Well, that's true. Yeah, that's true. If they do, you can sue him for whatever he sued him for. I don't think you'll have much success there, but have a safe trip to Honolulu, saving those turtles there, Angela B. I know you're kidding. Newbie of Death says, watch Waco, The Big Lie. Yeah, I've watched a lot of Waco stuff. I'm not sure if I've seen that one, but it is, there's a lot of interesting things that went on there. We have Sergeant Bob says, another big fed up mess was Ruby Ridge in Idaho, like Waco. For sure, do not trust the feds. Yeah, Ruby Ridge in Idaho. Yeah, that's another one. That was more recent, right? Oh, man. All right. So those were great questions. A lot of great comments. Thank you for all of your love and support over at Locals and on YouTube. I appreciate that. Let's give some shout outs to over in the chat room. Over on Locals, we've got Tweaks in the house with Want to Know. We got Gertjan Decker's in the house with I'm Not Gassed. Another Want to Know over there. They are chatting away with Vienticus Prime Thunder 7 and many others. Over on YouTube, shout outs to Manners, Martian Tech. We have Kenneth Reeder in the house. Lava Java Lava. Where's Lava Java Lava been? Good to see you, Lava. We have Sarah Brown. We've got Christine. We have JS and many others over there. Thank you to you all for your continued support. Really appreciate you being here. All right. We've got one more segment on the show today. So let's brace ourselves for it. Barack Obama, birthday bash of the century. He turned 60 years old. You probably saw a lot of the imagery, a lot of the videos and photography. Kind of looked like a big party when we're in the middle of a pandemic. And a lot of people are sort of panning the party, saying, oh my goodness, no masks. And this whole thing was not much social distancing. And it feels like a pretty big double standard when you're sitting at home getting your email from your school board and they say, oh, little Johnny has to mask up for the rest of the school year. Meanwhile, our royal class, the people who live above and beyond the rules, they get to go to Martha's Vineyard and spend 3 days in a very extravagant party. Okay, so that was going on, and it's very easy to sort of slam dunk and spike the football on the masks, but we're going to go one step further, and we're going to apply the U.S. Criminal Code. We're going to take a look at various different statutes here and ask ourselves whether Barack Obama and the Obama family, the Obama party, in collusion with the Secret Service and maybe even other feds, were committing some of the most heinous crimes that I have personally seen people get arrested for and imprisoned for. And so we're going to go through this, and we're going to do this piece by piece. We're going to start with a headline over from the Daily Mail. Exclusive, the party continues. BO's party, the 60th celebrations, roll into their third day with a birthday brunch over with Oprah at Martha's Vineyard. And I've got some highlights here, right? BO's 60th birthday party, Saturday night, Martha's Vineyard. Sunday, the party continued with a celebratory brunch over at Beach Road. A large crowd was seen on the balcony evening enjoying farm-to-table offerings. We've got Saturday night, former president was caught on video dancing, maskless, with his guest. Singer-songwriter Erykah Badu filmed Obama, posted a selfie. We had two DJs we're going to be spending a lot of time talking about. These are really some of the masterminds here in this criminal enterprise. They were there sharing pictures on Martha's Vineyard as well, despite there being a ban on pictures and video. Why might that be? Why might they want to ban photos of the illegalities happening there, huh? Food, cocktails. We have specially branded napkins, face masks, even the toilets were posted on social media, probably for disposing of things. We'll talk about that. Secret Service was there. They set up a no-fly zone. Obama, $12 million mansion. 300 to 400 guests were there. Alicia Keys saying happy birthday. John Legend saying happy birthday. 29-acre estate. Everybody was there, even though it was a, quote, trimmed-down guest list. We had, Beyonce, Jay-Z, Gayle King, Tom Hanks, Steven Spielberg, everybody else. And on Friday night, there was even a pre-party cocktail gathering at the Oceanside Resort. Okay, so we've got several different criminal statutes from the U.S. Code that we can take a look at. The first one we're going to identify is here, conspiracy. Let's take a look at U.S. Code 846, Title 21. It says, any person who attempts or conspires to commit any offense shall be subject to the same penalties as those described for the offense, okay? This is conspiracy. We see this all the time. We see this with the Governor Whitmer plotters. We see this with a lot of the January 6th defendants. And so we have to ask ourselves here, conspiracy. Is this a conspiracy? We have not defined any criminality yet, right? We haven't talked about any one of these underlying offenses. We're going to get there. But the first thing we need to do is establish a conspiracy. So let's give a look through at some of the photos that we saw. First and foremost, you can see that this looks like it's pretty dang orchestrated. This is actually a constructed tent that is being built right outside of his house, right? So this is clearly planned. It's been clearly something that has been in motion for a long time. And you're noticing, right, it's a big operation. We have a whole $12 million house right here. And these tents are bigger than the house, essentially. It goes all the way out into sort of the water, the bay. We've got two moving trucks over here. And you can see there's just a lot of activity going on. This might be a generator here for power. It's like a separate structure over there. So clearly, many people are involved in this. Certainly leads to ideas of collusion. Multiple people we have to take a look at. This is from inside the tent. Again, many people, presumably workers. Of course, nobody's wearing masks, but they are setting up the event. It doesn't really look scaled back. These look like almost like fabricated walls, very tall ceilings, not like like a tent that you might pitch if you're out there camping. And so this is a big deal. A lot of people involved in the conspiracy. This was so planned that you can take a look at these napkins here, 44 by 60, right? So the 44th president by 60, turned 60 years old, matching sunglasses, very clearly orchestrated. And this is a scene from outside the house, right? Very close, not much social distancing, not seeing many masks on these two gentlemen right here having a conversation. And so the whole thing is being orchestrated. We even have sniffer dogs that are being used to check people coming in and out of the property, right? So this is now something that you can sort of see. Why is this important? Well, we've got dogs, we've got security. So stuff that's going on inside of the property now is presumably allowed or acceptable. Okay, we have people coming to the property that are being screened, that are being checked to make sure that presumably there's nothing illegal or problematic or troublesome being brought in, right? So we have the sniffing dogs here. We've got multiple security apparatus. We have an ambulance that is ready to go. So if anybody gets injured inside the property, an ambulance is on site ready to take them away. We also have the entire Secret Service is out there. Okay, so they set up a no-fly zone around the residence, and we've got Secret Service staff. They're seen on the shoreline directly behind Obama's residence, not the president's. Now, you'll notice over here, we see some hints of potential illegalities going on over here, right? The Secret Service are in full view of this. We have a number of different libations over here, different alcoholic delights that are sort of, over here. Now, that in and of itself is not illegal. We do have some pots and maybe some manufacturing devices over here. Can't really see what those are, but certainly it looks like things might get a little bit rowdy. So we got alcohol over there. Who knows if people are going to be driving and drinking or if there's going to be any violence there, but the Secret Service is there, which they're kind of, impliedly approving this, aren't they? Okay, so Secret Service is there. Now, let's take a look at another U.S. code. I think it's pretty clear. Conspiracy exists. Secret Service is involved. Tents everywhere, all over the place. We have multiple people who are conspiring to make this thing happen. If there are illegalities that take place here, you can tie it to everybody, right? Everybody's involved in the conspiracy. Same thing that they do with all the Capitol Hill defendants, all of the January 6th protesters, all of the Governor Whitmer plotters. Everything's a conspiracy. And how do they get you on a conspiracy? Well, it's pretty simple. All they do is they just get your phone and they just tie your phone to a lot of the activity that took place. So let's go over to U.S. Code, 21 U.S. Code 843, another violation here, potentially now. We haven't identified any of the underlying criminality. We're going to get there, but we're doing some topical stuff first. It shall be unlawful for any person knowingly or intentionally to use any communication facility. Now, what is a communication facility? The statute defines that as any public or private instrumentalities used in the transmission of pictures or sounds, including mail, telephone, radio, or other means of communication. So what this means, folks, cell phones, right? If you have cell phones in the property, then and you're involved in this conspiracy and any of the underlying criminality, that's a problem. That's a whole separate offense under U.S. Code. This prohibits you from using telecommunication devices in the commission of crimes. And so here we have three pictures here of a woman who I think is Erica. You can see Erica Badu over on Instagram. Never heard of her, but apparently she's big enough to be partying with Obama. So she's hanging out over there. Now, again, no real criminality happening here, right? Now, unless you're somebody who wants to sort of define not wearing a mask as criminal, right? No mask, 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 no mask. Okay, so a lot of no masks there, and it's all being caught on cell phone footage. So obviously you might say, well, so what? There's no federal crime against wearing a mask, which is true for now. But it could easily be, right? We've heard this before, that if you don't wear a mask, you are killing somebody, right? You're actually killing me, or you're going to put my life in danger. We see that all over CNN. I think every 15 minutes, there's a rule on CNN that they have to bring the next guest out there and they have to hyperventilate on air about how you are killing their grandmother if you don't put a mask on. So for those people, if you get them on the jury and you show them this anti-masking behavior, right? You might see a significant portion of them that actually consider this to be attempted murder or reckless endangerment or something like that. It could get bad, and they're in clear violation of that. Now, I am obviously not one of those people that has a lot of complaints about the mask. Wear them or don't, I don't really care. But there are people in this country that would look at this and just say, whoo, there are going to be at least a million dead grandmas as a result of this. No masks, no masks, no masks. They're not even 6 feet apart, maybe close. But, we got a lot of air being spread around in that room. And so this could be problematic for some people. Now, this is the video footage. Again, we're taking a look at what's happening here. This is a video from inside this criminal enterprise, as we're going to see. All right, so apologies on the volume on that. That was very loud for you and in my earlobe. So, but you saw what was happening there, right? It was Barack Obama having a good time. That's all right. That's fine. No masks. That's okay. No problem at all. Let's see, though, if we can dig into this a little bit further. Now, we've done some of the heavy lifting. We know what the criminal statutes are for conspiracy and for use of a telephone in the commission of felonies. Let's take a look now and see if we can identify some real criminal behavior. And folks, this is where it gets juicy. And I do have to give a little bit of a content warning here. We are going to be looking into marijuana. Marijuana is going to be in this segment, folks, because it was running rampant around the Obamas. Let's take a look at what happened here.
Actually, we did take care of you guys, yes.
Oh, what?
Got some back there for you with a bottle, too.
Come on, man.
Whoa. I know you lying to me.
No, man.
I know.
Okay, so did you hear what he said? He said, I've got something back there for you, too, along with a bottle. So listen to that closely. Let's play that one more time.
Yeah, come on, man. You don't.
Let's listen in, because he's telling these. So there's a golf cart going into the Obamas, and he's saying, I've got something for you back there. Let's listen in closely. This is important here.
Actually, we did take care of you guys, yes.
Oh, what?
Got some back there for you with a bottle, too.
Come on, man.
I know you lying to me.
No, man.
I know you ain't
Yeah, come on, man. You can't play with people like that, bro.
Listen. Oh, it's good.
Oh.
It's okay, yeah. No, I got everything.
There it is, folks.
Oh, my God. Yeah, I would like a drink.
Yeah, I like a Hennessy on the rocks.
I like apple slappy cranberry or Tito's and cranberry. And cranberry.
Hennessy on the rocks.
Tito's and cranberry.
Yeah.
Tito's and cranberry.
Oh, this is presidential.
This is presidential, folks. That's an admission right there.
What you doing? Okay.
Whoa.
Done a lot of things before. Never smoked at the president's crib.
Oh, that's an indictment right there, folks. Never smoked at the president's crib. Oh, my goodness. You know, marijuana is still illegal federally, all right? Let's dive into this statute here. 21 U.S. Code 844, penalties for simple possession. So that person clearly in violation of federal law. It is unlawful for any person to intentionally possess a controlled substance. You can read the rest of the statute there. Now, the thing I wanted to point out here, white cookies, and you'll notice it says 19% THC. Uh-oh. So 19% THC, which is, you know, it's not even any good weed, unfortunately for them. You know, those are amateur numbers. You know, if you really want to get into the high potency strains, those are going to be significantly more than that, something like 20 to 25%. 19%, you know, for an average strain, 18 to 20% is typically what you see. But nowadays, it's legal in most places. So the strain, you know, the numbers are actually higher than that. That's kind of, you know, garbage weed. But it's kind of socialist weed, really, if you want to get down to it, kind of communist weed over there. But that's what they've got. Now, my question was, why is that percentage not higher, right? You would imagine that if you're the president, former leader of the free world, you've got some, you know, 25% stuff, some really ridiculous stuff. And they didn't. So either Obama's given him the terrible marijuana, or this is illegal. He couldn't bring in the good stuff because he had to, you know, bootleg it in there under the dark of night. So it's really complicated. I don't know, but it is something that you want to look into. 19%, right? Whatever it is. Okay. So we've got that simple possession. That's pretty obvious. We also have this concept here of what's called a continuing criminal enterprise. U.S. Code 848, also a violation of this. Let's see here. A continuing violation if a person is engaged in a continuing criminal enterprise. If there's a, let's see, continuing series of violations here, which are undertaken by such a person in concert with 5 or more other persons, right? Occupies a position of organizer, which I think would implicate Barack Obama clearly, or Michelle or somebody from the team, right? Somebody who organized all of this is responsible. Position of management. Let's see, 20 years for running a continuing criminal enterprise is, I think it's justified for what we saw there. Continuing criminal enterprise, 20 years, $2 million fine also as well. So, all right, here, now it says mandatory minimum of 20 years. Mandatory life and death penalty is available also under certain circumstances. So, yeah, I'm not sure if this matches. Leader of an organization, engaged in a continuing series of drug violations. So I'm not sure if I would categorize it as continuing, you know, because it was just sort of a 3-day thing. Maybe we'll see. Now here we have the two sort of masterminds, TJ Chapman and DJ Musician, and then Trap Beckman. They shot footage and snapped photos while talking to their followers. Wow, okay. So, all right, well, that's another one. They're smoking cannabis. So, yeah, I think it does, right? It's a series of drug violations. You can find a U.S. prosecutor who found that to be factual. Yeah, it's a continuing series of drug violations. And their communist weed was delivered as well. How about this? We have U.S. Code 856. And if you think I'm being facetious here, there are people that are charged for drug crimes under circumstances like this. They're not the president who's turning 60 on Martha's Vineyard. These are people who are, 25 to 30 who are having parties in inner city Chicago. Different rules for different folks. Okay, so how about this one? 21 U.S. Code 856, maintaining a drug-involved premises. Uh-oh. How about this? Maintain any place, whether permanently or temporarily, even temporarily, for the purpose of distributing any controlled substance. That's it right there, folks. Maintaining a place. They actually built a place, right? They opened and maintained this place that was for the purpose of distributing drugs and having a party. Even the Secret Service members were out there with booze. All right. We have any person who violates this section, another 20 years, federal law there. And if Barack Obama doesn't like this, well, he could just take it up with Joe Biden, because Joe Biden is responsible for a lot of this. He wrote these laws back in the 1980s and 1990s. U.S. Code 856 includes the owners and the landlords of these rental properties. All right, well, there's Obama running the whole thing. Here's the back end. Okay, we've got some other evidence of criminality over here. Alcohol. We have a toilet over here for flushing drugs down the toilet, if you're concerned about this. Luxury toilets, right? Kind of dark, alcohol, dark and seedy environments. Toilet for flushing Hunter Biden's crack pipe down here. Hunter Biden can actually use this. This is supposed to be for marshmallows, right? Or crack. So conveniently, they have this little crack booth set up. No, we're doing s'mores over here, roasting marshmallows. Yeah, right. Give me a break. All right, so that was all pertinent to maintaining a drug-involved premises. This is also known by the feds as the crack house statute. So I think that fits because we have a crack pipe, crack heating device over here. So the crack house statute I think is appropriate. And our last U.S. code here is 1952, interstate in foreign travel or transportation for racketeering, right? So whoever travels in interstate or foreign commerce or uses mail or any facility to commit any crime of violence furthering the unlawful activity. Oh my gosh. And look, folks, look at these just monsters. Can you believe this? I got Stephen Colbert over there flying into the Obama's crack house along with John Legend and Chrissy Teigen. They are clearly in interstate travel, right? You don't need this much stuff to just go to a birthday party. So they are engaged in interstate travel. And even, folks, Hunter Biden's ex-wife, Kathleen, showed up along with daughter Finnegan. But I don't know why Hunter Biden wasn't there, or Joe Biden. Where was Joe Biden on this thing? Were they there either? All right. So that was a segment, wasn't it? Let's take a look at some questions. I know we've got a lot of questions on this segment. So let's hop on over to watchingthewatchers.locals.com. And if you asked a question about this segment previously, I did not get it because I'm resend those and we'll get to them in this segment. All right. So we have our first one here. Nope. That one is from the last segment. We have Barack Obama says, "Hey, Hunter, at my birthday party, would you give me millions of dollars when you were part of the infrastructure deal if I I can't say that. All right. Three Girlie says, I'm surprised. That was from the last segment. I think I got that. We're a little bit out of order on this. We got Sergeant Bob says, why not in his native Chicago with Mayor Lightfoot? Too many unhinged criminals with firearms that Chicago PD is discouraged from interfering with despite a huge percentage of victims from one particular racial group. Much safer at a secluded estate on Cape Cod. Ted Kennedy's favorite party place. Yeah, so Sergeant Bob is saying, why'd they go out there to Martha's Vineyard over there? Why aren't they doing this in Chicago, where Barack Obama was a senator for a long time? That's a good point. Gavin Newsom says, I missed the party. They told me it was at the French Laundry. I thought they liked me. Sorry, Gavin. You're on the outs, brother. I think you're going to lose your recall election, and you're no longer part of the in club anymore. Hopefully that happens. Thunder7 says, but Rob, the rules are for the slaves like us. They don't apply to the plutocrat elites. Leave them alone. Anyone who criticizes the Obamas are racist. white supremacists and Nazis. I know I'm part of the problem over here. Thank you, Thunder7. We have Screw the Mainstream Media, who says, in Australia, the mainstream media are pro-lockdown, pro-vaccine, and mask mandate. They spew propaganda about COVID. 9 News keeps talking about the COVID measure. On Barack Obama party, they conveniently did not talk about the lack of masks and vaccinated people. Mainstream media will present themselves as neutral when reporting inconvenient topics, but when it comes to their political narrative, they either lambast or speak positively of. Screw the mainstream media. Yeah, you're going to see that, right? And it's like a... folks, I don't care about the marijuana at all, right? I don't care about it for a second. I think it is ridiculous, though, that we have people who are still being incarcerated for this stuff under those statutes. That's kind of the point of that whole segment. This is all true in federal law. Those are all real statutes, and they can all be applied to any person you apply them to, right? In this case, it was obnoxious and obvious that this was sort of, being facetious and over the top, I think. But it's also something that happens every single day in this country. People are brought in under charges for those criminal statutes for marijuana violation. Our rulers at B have no qualms about letting that stuff run rampant in their properties. But if they catch you doing it in a state where it's not legal, you might actually go to prison for that, right? It happens. And it happens in situations with people that have prior backgrounds, right? Somebody has got prior 3 felonies. They get caught with a marijuana joint. Boom. That's a 4th offense. We have a 3-strike rule. Thank you, Joe Biden. Talking about Barack Obama right now. But it is a problem. They don't ever get in trouble for it. Everybody else does. KGB Gulag says, what to bet that Barack Obama would send the KGB to arrest Erykah Badu for making Barack Obama look like a fool? They'd probably be sent to the Gulag and probably get Epstein. Yeah, I'm sure she is uninvited from all future Barack Obama parties. We've got Peely Wally says, hey, Rob, I'm pretty sure I saw Hunter Biden in disguise at the party. Come on, man. That guy can sniff out an illegal act anywhere and jump right into the middle of it to enjoy. Are you proud of me, Dad? Come on, man. Yeah, that's from Peely Wally. So it was either Hunter Biden was there in disguise or his ex-wife, I think Hallie, who I think, was she also his brother's ex-wife too? Maybe, I'm not sure. But she had that suitcase that looked pretty empty. She's probably bringing back all the illegal drugs and crack and the crack pipe back to Hunter in the White House. We have Aircraft Mech says, the reason the weed, why 19% is funny. All night Obama would say, anybody want the COVID-19? Inhale it, baby. Yeah, 19%. And I like how they wrote 19% on there. Like that's a big, like that matters, right? We have over here, we've got Want to Know says, Rob, you're talking about the greatest, smartest black president the USA ever had. He didn't invite me. What about the private jets that are murdering the whole planet by global warming and killing animals and old people by the heat waves? That's true. Every single jet that touched down there was murdering your future children and their future children. How do you feel about that, America? We have another one here coming in, says, Chris Cuomo said, did you see New York Governor Cuomo? I thought I saw him. Was Chris Cuomo there? I think both those guys are in hiding. They should certainly be. All right, well, let's see what came in over on YouTube. We have over here, this was, I think, from the last segment, but Mr. Ted Offensive says, I can't believe Dick DeGuerin is involved with this. It would be like Robert Barnes letting one of his partners file something like that. I just can't see it. It's pronounced DeGuerin. Thank you for that. Yeah, for Mr. Ted Offensive. I can't imagine either. I poked around their website. This was from the last segment. I poked around their website, and it looked pretty reputable. So to have an attorney file a document like that with the other law firm's email address on it. So I think he just probably forgot to copy and paste the correct bottom part. Or maybe he's filing lawsuits like sort of counsel from DeGuerin. But he used the Washington law firm and then signed DeGuerin and Dixon, DeGuerin.com. DeGuerin.com. So it sort of is hinting that maybe he's connected with the firm. Does DeGuerin want that lawsuit being filed on his name, under his name? Probably not. We have over here, says Barack Obama says, I love celebrating my birthday after drone striking hundreds of Muslims. Booyah. That's from Barack Obama in the house. He's still having a good time. We have VP says, with the super chat says, there were children there, John Legend. How many years for that? Yeah, that's a good question. That's right. Criminal endangerment of a minor. Look, they're already in pretty hot water. You saw 20 years, 20 years, 20 years. It's just it's only going to get worse from there. So they're in trouble. And I think that's it for the super chats and for the questions over from watchingthewatchers.locals.com. I want to thank all of our great questions that came in today. We had some new members who signed up over there supporting us at that community. Let me get some shout outs because we got some good signups this weekend. Big shout out over to JM Allen 4411. Thank you for joining us. We've got Radase in the house, signed up for the year. Grateful to have you as well for the full year. We got Stoic RD in the house. Love Stoicism. By the way, that book, The Daily Stoic, is something that I check in with. I don't read it daily, but for me, it's like the weekly Stoic, and I sort of catch up on the days. Love it. It's been actually very good. I'm trying to read it more on the daily, but the Daily Stoic, it's like $8 on Amazon. Goodbye. Thank you for being here, Stoic. We got Wendy Deer is here. Hello, Wendy Deer. We have D. Roddig 188. Saw him in the chat over here today. We've got Laura SB. Welcome to you as well. I'm glad that you're here. We have The Real Patriot who signed up. The Real Patriot in the house, along with Mary B. 585. So grateful for all of you to join our community. You signed up over the weekend. I'm thrilled to have you. Shout outs to the people who signed up last week. Christina G. We have Dutch Cheese, Outside Voice, Teeny Teen, Easy, and Atul 144 all signed up, and we're grateful to have you. We have a monthly meetup coming up soon here in a couple weeks. We got on August 28th. 2021, 7 to 8 p.m. We have a Zoom meetup that we have. I think this is I can't remember. I think this is our 5th one. Maybe our 4th one. I don't know. But they're a lot of fun. We have about 35 to 40 people on, and we sort of just turn the cameras on if you want, turn them off if you don't. And we just kind of get to know each other, ask some questions, and offer some feedback and some suggestions for the show. And it's a lot of fun. And so we would love it if you joined us on the next one, as well as joining our community, because a lot of people post a lot of great things over there. I'm spending a little bit more time sort of, commenting and then, gathering some information for some of the other projects that I'm working on. And so all of that is being curated and cultivated and nurtured lovingly. We want you to come join our community at watchingthewatchers.locals.com. So go and check us out. Once again, I want to thank everybody who signed up and joined us recently over there. Big thanks to all the super chats that came in today. Really do appreciate that. Curtis Bartle, Ben Dover, David Elkins, Angela B, Newbie of Death reviews stuff. We got Lava Java Lava in the house. Didn't have a message, but Lava Java Lava, it's been a long time since I've seen you, my friend. I'm glad that you're back here. We got Mr. Ted Offensive with several of those. I appreciate him, along with VP and others. Thank you all for your continuing support. Over on Locals, big shout outs before we wrap up for the day. We got Farmer's Daughter, Vienticus Prime. We've got I'm Not Gas, Gertjan Decker, Farmer's Daughter, Tweak, and many others over there. Over on YouTube, final goodbyes over to Curtis Bartle. We've got K-Bean, Real Fanning, Weeby, and Zorro. Appreciate all of you. It's been a lot of fun, my friends. We're going to be back here, same time, same place tomorrow, 4 p.m. Arizona time, 5 p.m. Mountain, 6 p.m. Central, 7 p.m. on the East Coast. And for that one Florida man, everybody else have a tremendous evening. Sleep very well. I'll see you right back here tomorrow. Bye-bye.